Section 415 Appeals from Convictions. Plain English explanation. Section 415 explains who can appeal against a criminal conviction and to which court the appeal can be made, depending on which court convicted the person and the sentence imposed. Key points explained. Appeal to the Supreme Court. If a person is convicted by the High Court in its extraordinary original criminal jurisdiction, meaning the High Court itself tried the case as a first court, they can appeal to the Supreme Court of India. Appeal to the High Court. If a person is convicted by a sessions judge, additional sessions judge, or any other court where the sentence is more than 7 years imprisonment, they can appeal to the High Court. Also, if one person in a trial receives a sentence of more than 7 years, others convicted in the same trial may also appeal to the High Court. Depending on the full text, which continues into subsections, there may be additional categories of appeal for lesser sentences and appeals to sessions courts. If you want, I can provide those two. Purpose of Section 415. To set out the right to appeal clearly based on the court that convicted and the severity of punishment. It ensures that serious convictions can be reviewed by higher courts for fairness and legality. Simple examples. Example 1. A high court convicts someone in a special criminal trial. That person can appeal to the Supreme Court. Example 2. A sessions judge convicts someone and sentences them to 10 years imprisonment. That person can appeal to the High Court. Bharatiya Nagarik Suraksha Sanhita, 2023 Section 416. Section 416. No appeal in certain cases. Plain English explanation. Section 416 lists the situations where no appeal is allowed, even though a person has been convicted. It limits unnecessary appeals in minor cases or cases decided with consent. Key points explained. No appeal for petty sentences. No appeal shall lie if a magistrate passes any of the following sentences. Fine only, up to the prescribed small amount. Imprisonment for a very short duration, or both fine and short imprisonment as specified by law. Conviction on plea of guilty. If a person is convicted on his own plea of guilty, no appeal is allowed against the conviction. However, an appeal may be allowed only regarding the legality or extent of the sentence, if permitted by law. Special or summary proceedings. In certain summary or special proceedings, where the law intends speedy disposal, appeals are restricted. Purpose of Section 416. To prevent overburdening appellate courts with minor cases. To ensure speedy justice in petty offences. To give finality to convictions based on voluntary guilty pleas. Simple examples. A person is fined 200 rupees by a magistrate for a minor offence, no appeal allowed. A person pleads guilty and is convicted, he cannot appeal against conviction, but may challenge an illegal or excessive sentence. Bharatiya Nagarik Suraksha Sanhita, 2023 Section 417. Section 417. Appeal in case of acquittal. Plain English explanation. Section 417 explains who can file an appeal when an accused person has been acquitted, found not guilty by a criminal court, and with whose permission such an appeal can be filed. Key points explained. Who can appeal against acquittal? The state government or the central government in cases investigated by central agencies, or, in certain cases, the complainant with special permission. Permission, leave, of the court is required. An appeal against acquittal cannot be filed as a matter of right. The appellant must first obtain leave, permission, from the High Court. Appeal by the complainant. If the case was instituted on a private complaint, not a police case, the complainant may appeal against acquittal only after obtaining special leave of the High Court. Purpose of requiring leave: to ensure that acquittals are not challenged casually, to respect the principle that an acquitted person enjoys a presumption of innocence. Purpose of Section 417: to balance the rights of the accused and the interest of justice, to prevent frivolous appeals against acquittals, to allow appeals only in deserving cases. Simple example: a trial court acquits an accused. The state believes the acquittal is legally wrong. The state must first seek permission from the High Court. Only if permission is granted can the appeal against acquittal be heard. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 418. Section 418: Appeal against conviction of accused found guilty on trial held by High Court. Plain English explanation. Section 418 provides the right to appeal to the Supreme Court when a person is convicted by the High Court itself in a trial conducted by the High Court as the court of first instance. Key points explained. When this section applies: when the High Court conducts the trial itself, not as an appellate court, and the accused is convicted and sentenced by the High Court. Right to appeal: the convicted person has a right to appeal directly to the Supreme Court of India. Nature of the right: this appeal is a statutory right, not merely discretionary. It ensures that even convictions by a High Court get one higher level of judicial scrutiny. Purpose of Section 418: to protect the right to appeal even in exceptional cases where the High Court acts as a trial court, to uphold fairness and due process by allowing review by the highest court. Simple example: a High Court tries a sensitive criminal case directly. The accused is convicted by the High Court. Under Section 418, the accused can appeal to the Supreme Court against that conviction. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 419. Section 419: Appeal against sentence. Plain English explanation. Section 419 allows a convicted person to appeal only against the sentence, not against the conviction, in specific situations permitted by law. Key points explained. Limited scope of appeal: the appeal is only about the sentence. Punishment: the finding of guilt, conviction, is not challenged. When this applies: commonly applies where the accused pleaded guilty, or the law restricts appeal against conviction but allows appeal on sentence. What can be challenged? The appellant may argue that the sentence is illegal, excessive, or not in accordance with law. Which court hears the appeal? The appeal lies to the appropriate appellate court depending on the court that passed the sentence and the nature extent of punishment. Purpose of Section 419: to ensure fairness in punishment even when conviction is accepted or final, to allow correction of illegal or disproportionate sentences, to balance finality of conviction with justice in sentencing. Simple example: an accused pleads guilty and is convicted. He believes the punishment is too harsh or unlawful. Under Section 419, he may appeal only against the sentence, not the conviction. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 420. Section 420: Appeal by the state government against sentence. Plain English explanation. Section 420 gives the state government the right to appeal against the sentence passed by a criminal court if the sentence is considered inadequate or improper. Key points explained. Who can file the appeal? The state government. What can be challenged? Only the sentence, not the conviction. The appeal is usually filed when the punishment is too lenient or not in accordance with law. Which court hears the appeal? The appeal is filed before the appropriate appellate court, depending on the court that passed the original sentence and the nature of the punishment. Purpose of such appeal: to ensure that punishment matches the gravity of the offense and serves the interest of justice and society. Safeguard for the accused. The accused is given a reasonable opportunity to be heard before the sentence is enhanced. Purpose of Section 420. To allow the state to correct unduly light sentences. To maintain uniformity and seriousness in criminal punishment. To uphold public confidence in the justice system. Simple example. A person is convicted of a serious offense but given a very light sentence. The state government believes the punishment is inadequate. Under Section 420, the state may appeal for enhancement of the sentence. Bharatiya Nagarik Suraksha Sanhita, 2023 Section 421. Section 421, Abatement of Appeals. Plain English explanation. Section 421 explains what happens to a criminal appeal if the appellant, person who filed the appeal, dies during the pendency of the appeal. Key points explained. General rule: appeal abates on death. If the accused appellant dies, the appeal automatically comes to an end, abates. Exception: appeals involving fine. If the appeal is against a sentence of fine, the appeal does not abate. The legal representatives of the deceased may continue the appeal because the fine affects the property estate of the deceased. Composite sentence: imprisonment plus fine. If the sentence includes both imprisonment and fine, the appeal abates regarding imprisonment, but it continues regarding the fine. Purpose of continuation: to protect the financial interests of the deceased's family or estate. Purpose of Section 421: to bring finality where punishment is personal, imprisonment. To ensure fairness where punishment affects property or money. To avoid unnecessary continuation of appeals with no practical effect. Simple examples. An accused appeals against imprisonment only and dies, appeal ends. An accused appeals against a fine and dies, legal heirs may continue the appeal. Sentence is 3 years imprisonment plus 50,000 rupees fine. Appeal ends for imprisonment, continues for fine. Bharatiya Nagarik Suraksha Sanhita, 2023 Section 422. Section 422, Effect of abatement on pending appeals. Plain English explanation. Section 422 explains what happens procedurally when an appeal abates, comes to an end, especially after the death of the appellant, as provided under Section 421. Key points explained. When appeal abates. If an appeal abates due to the death of the appellant and it is not an appeal concerning fine, the appellate court will not proceed further with that appeal. Effect on court proceedings. The appellate court will record the abatement and close the appeal proceedings to that extent. Exception remains for fine. If the appeal continues for fine, as allowed under Section 421, the court will proceed only to decide issues relating to the fine, not imprisonment. Finality. Abatement brings finality to the conviction and sentence to the extent the appeal has abated. Purpose of Section 422: to ensure clarity and closure in appellate proceedings, to avoid unnecessary hearings when the appeal cannot legally continue, to align procedure with the principle that personal punishment ends with death. Simple example. An accused files an appeal against imprisonment and fine. He dies during the appeal. Under Sections 421 and 422, the appeal ends regarding imprisonment. The court records abatement and proceeds only on the issue of fine, if challenged. Bharatiya Nagarik Suraksha Sanhita, 2023 Section 423. Section 423, Powers of the Appellate Court. Plain English explanation. Section 423 explains what an appellate court can do after hearing an appeal. It lays down the range of powers available to the appellate court while deciding criminal appeals. Key points explained. Confirm the decision. The appellate court may dismiss the appeal and confirm the conviction and sentence passed by the lower court. Reverse or modify the decision. The court may reverse the conviction and acquit the accused, or alter the finding or reduce, increase, or change the sentence according to law. Order retrial or further proceedings. The appellate court may order a retrial or send the case back to the lower court for fresh proceedings if serious defects are found. Suspend sentence during appeal. The appellate court may suspend execution of the sentence and grant bail to the accused during the pendency of the appeal. Fair hearing mandatory. No adverse order shall be passed without giving the accused a reasonable opportunity of being heard. Purpose of Section 423. To give appellate courts wide authority to correct errors, to ensure justice, fairness, and legality in criminal convictions and sentences, to allow effective judicial review of lower court decisions. Simple example: a trial court wrongly convicts an accused. On appeal, the appellate court may set aside the conviction and acquit the accused under Section 423. Or, if the sentence is too harsh, it may reduce the punishment. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 424. Section 424, Judgment of Appellate Court. Plain English explanation. Section 424 explains how the appellate court must deliver its judgment after deciding a criminal appeal. It focuses on clarity, reasoning, and communication of the appellate decision. Key points explained. Form of the judgment. The appellate court must record its judgment in writing. The judgment should clearly state the points for determination, the decision on each point, and the reasons for the decision, signature and date. The judgment must be signed by the judge, S, and dated as required by law. Communication of judgment. A copy of the appellate judgment must be sent to the trial court whose decision was appealed and any other court or authority as required. This ensures the judgment is properly implemented. Binding effect. The lower court must act in accordance with the appellate judgment, such as releasing the accused, modifying the sentence, or conducting further proceedings if ordered. Purpose of Section 424. To ensure transparency and reasoned decision-making in appeals. To maintain judicial discipline and consistency. To ensure effective execution of appellate court decisions. Simple example: an appellate court reduces a sentence after hearing an appeal. Under Section 424, it must clearly explain why the sentence is reduced and send the judgment to the trial court, so the jail authorities and lower court implement the new sentence correctly. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 425. Section 425, Order of Appellate Court to be certified to lower court. Plain English explanation. Section 425 explains what the appellate court must do after it passes an order in an appeal. It ensures that the appellate court's decision is officially communicated and properly carried out. Key points explained. Certification of the order. The appellate court must certify, formally send, a copy of its order or judgment to the trial court or the lower court whose decision was appealed. Duty of the lower court. After receiving the certified order, the lower court must act according to the appellate court's decision, such as releasing the accused, modifying the sentence, or taking further steps ordered. Ensures implementation. This section ensures that appellate decisions are not merely theoretical but are actually enforced. Purpose of Section 425. To maintain coordination between appellate and lower courts. To ensure prompt and correct execution of appellate orders. To give finality and effect to appeal decisions. Simple example: an appellate court sets aside a conviction. Under Section 425, the order is certified and sent to the trial court. The trial court then immediately releases the accused and closes the case accordingly. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 426. Section 426, stay of sentence pending appeal, release of appellant on bail. Plain English explanation. Section 426 empowers the appellate court to suspend, stay, the execution of the sentence while an appeal is pending, and to release the convicted person on bail during that period. Key points explained. Suspension of sentence. When an appeal is filed, the appellate court may temporarily suspend the sentence imposed by the lower court. This means the punishment, especially imprisonment, will not be carried out until the appeal is decided. Release on bail. If the appellant is in custody, the court may release him on bail or release him on a bond with or without sureties. Discretion of the court. Granting a stay or bail is not automatic. The court considers factors like seriousness of the offense, length of sentence, chances of absconding, conduct of the accused, mandatory opportunity to prosecution. In serious cases, especially where a severe sentence is involved, the court should give the prosecution an opportunity to be heard before granting suspension of sentence. Purpose of Section 426: to protect the right of appeal, to prevent irreversible punishment before the appeal is finally decided, to balance the rights of the accused with the interest of justice. Simple example: a person is sentenced to 5 years imprisonment. He files an appeal. The appellate court may suspend the sentence and grant bail under Section 426 until the appeal is decided. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 427. Section 427, sentence on offender already undergoing sentence. Plain English explanation. Section 427 explains how a new sentence will run when a person is already serving a sentence for another conviction. Key points explained. General rule: consecutive sentences. If a person already serving a sentence is later convicted in another case, the new sentence will start after the earlier sentence ends. This is called consecutive sentencing. Court's discretion to order concurrent sentence. The court has the power to direct that the new sentence shall run at the same time as the previous sentence. This is called concurrent sentencing. This depends on nature of offenses, facts of the case, interest of justice. Special rule for life imprisonment. If a person already undergoing life imprisonment is again sentenced to life imprisonment or imprisonment for a term, the new sentence will run concurrently with the existing life sentence. Purpose of Section 427: to clearly regulate multiple sentences, to give courts flexibility to impose fair punishment, to prevent unnecessary or excessive imprisonment, especially in life sentence cases. Simple examples: a person serving 2 years is later sentenced to 3 years. Normally, total jail time 5 years, consecutive. If the court orders concurrency, total jail time 3 years, runs together. A life convict receives another life sentence. Both sentences run together, not one after the other. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 428. Section 428, set-off of period of detention undergone by the accused. Plain English explanation. Section 428 says that any time an accused has already spent in custody during investigation, inquiry, or trial must be deducted, set off, from the total period of imprisonment finally awarded on conviction. Key points explained. Who gets the benefit? An accused person who is detained in jail before conviction. What period is counted? Time spent in custody, during investigation, inquiry, or trial of the same case. How set-off works. The period already spent in custody is subtracted from the sentence imposed after conviction. Applies to imprisonment. Set-off applies to imprisonment for a term. It ensures a person is not punished twice for the same period of detention. Purpose of Section 428: to ensure fairness in sentencing. to prevent excessive or unjust imprisonment, to recognize that pretrial detention is also loss of liberty. Simple example: an accused spends 1 year in jail during trial. Later, he is sentenced to 3 years imprisonment. Under section 428, the 1 year is deducted. He will now serve only 2 more years. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 429. Section 429, Saving of Inherent Powers of the High Court. Plain English explanation. Section 429 clarifies that nothing in this chapter takes away the inherent powers of the High Court. These inherent powers exist to ensure justice, fairness, and proper functioning of courts. Key points explained. Inherent powers preserved. The High Court retains its inherent powers even if they are not specifically mentioned in the code. Purpose of inherent powers. These powers may be used to give effect to any order passed under the code, to prevent abuse of the process of any court, or to secure the ends of justice, not limited by procedural rules, even if procedural provisions are silent or inadequate. The High Court can act to ensure substantial justice. Used sparingly. These powers are exercised carefully and in exceptional cases, not routinely. Purpose of Section 429. To ensure justice is not defeated by technicalities. To give the High Court flexibility to correct serious injustice. To prevent misuse of legal processes. Simple example: a criminal proceeding is clearly malicious and meant only to harass someone, even if no specific provision applies. The High Court may quash the proceedings using its inherent powers under Section 429 to prevent abuse of process. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 430. Section 430. Cases in which no appeal lies. Plain English explanation. Section 430 states that when a criminal case has already been decided in appeal, no second appeal is allowed, except where the law specifically permits it. Key points explained. One appeal rule. Once a case has been heard and decided by an appellate court, no further appeal can be filed against that decision. Exception where law allows. A further appeal is possible only if the law expressly provides for it. A further appeal is possible only if the law expressly provides for it. For example, appeal to the Supreme Court in certain situations. Revision still possible. Even when a second appeal is barred, the High Court may still exercise revision or inherent powers if legally permissible. Purpose of Section 430. To ensure finality of criminal proceedings. To prevent endless appeals and delays. To maintain judicial efficiency and certainty. Simple example: a magistrate convicts an accused. The accused appeals to the Sessions Court. The Sessions Court decides the appeal. Under Section 430, no second appeal lies against that decision, unless a special law allows an appeal to a higher court. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 431. Section 431. Conflicting judgments of courts of appeal. Plain English explanation. Section 431 deals with a situation where two or more appellate courts give conflicting, different, or contradictory judgments on the same legal question. It provides a method to resolve such conflict and maintain uniformity in law. Key points explained. When this section applies. When different appellate courts give conflicting decisions on the same point of law or similar legal questions. Reference to the High Court. In such cases, the matter may be referred to the High Court for a final and authoritative decision. Binding decision. The decision given by the High Court on the referred question becomes binding and helps ensure uniform interpretation of law. Purpose of reference. To avoid confusion in law, inconsistent judgments, and Unequal application of legal principles. Purpose of Section 431. To ensure consistency and certainty in criminal law. To maintain uniform judicial standards. To strengthen the authority of the High Court in settling legal disputes. Simple example. To appellate courts interpret the same provision of law differently. Due to this conflict, lower courts are confused about which interpretation to follow. Under Section 431, the issue may be referred to the High Court, whose decision will settle the matter. Bharatiya Nagarik Suraksha Sanhita, 2023 Section 432. Section 432, Power to suspend or remit sentences. Plain English explanation. Section 432 gives the appropriate government the power to suspend, temporarily stop, or remit, reduce or cancel the whole or part of a sentence passed on a convicted person. Key points explained. Who has the power? The state government or the central government, depending on the offense and the authority that prosecuted the case. What the government can do: suspend the execution of the sentence, temporarily stop it, or remit the sentence, reduce the punishment or forgive part of it. Conditions may be imposed. The government may impose conditions while suspending or remitting the sentence. If the convicted person violates the conditions, the sentence can be revived. Court's opinion. Before exercising this power, the government may seek the opinion of the court which passed the sentence. The court must provide its opinion along with reasons. Effect of suspension or remission. Suspension or remission does not erase the conviction. It only affects the execution of the sentence. Purpose of Section 432. To allow mercy, reform, and rehabilitation of offenders. To provide flexibility for humanitarian or public interest reasons. To balance punishment with compassion. Simple example. A person is sentenced to 10 years imprisonment. After serving 5 years, the government remits to years of the sentence. The person now has to serve only 3 more years. Bharatiya Nagarik Suraksha Sanhita, 2023 Section 433. Section 433, Power to commute sentence. Plain English explanation. Section 433 gives the appropriate government the power to commute, change, one form of punishment into a lighter form without changing the conviction. Key points explained. Who has the power? The appropriate government, state or central, depending on the case. What commutation means? Commutation means substituting a harsher punishment with a lighter one. The conviction remains unchanged. Only the nature of punishment is altered. Types of commutation allowed. The government may commute. Death sentence, life imprisonment. Life imprisonment, imprisonment for a term. Rigorous imprisonment, simple imprisonment. Imprisonment fine. Consent of the convict not required. The government can commute the sentence even without the consent of the convicted person. Independent of courts. This power is executive in nature and is separate from appeals, revisions, or judicial review. Purpose of Section 433. To allow leniency and reform in deserving cases. To give the government flexibility for humanitarian reasons, public interest, age, health, or conduct of the prisoner. To balance justice with mercy. Simple example. A person is sentenced to life imprisonment. The government commutes it to 20 years imprisonment. The conviction remains the same, but the punishment is reduced. Bharatiya Nagarik Suraksha Sanhita, 2023 Section 434. Section 434, Power to commute sentence of death. Plain English explanation. Section 434 specifically deals with the power to commute a death sentence. It clarifies who can decide on commutation when the punishment awarded is death. Key points explained. Who has the power? The appropriate government has the power to commute a death sentence. This power is exercised subject to the Constitution of India, especially provisions relating to mercy petitions. Nature of commutation. A death sentence may be commuted to life imprisonment or another lesser punishment as permitted by law. Independent of courts. This power is executive, not judicial. It is separate from appeals or revisions pending before courts. No consent required. The commutation can be done without the consent of the convicted person. Purpose of Section 434: to provide a final humanitarian safeguard in death penalty cases, to ensure careful executive consideration before a death sentence is carried out, to align criminal procedure with constitutional mercy powers. Simple example: a court sentences a person to death. After considering mercy grounds, the government commutes the sentence to life imprisonment. This action is valid under Section 434. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 435. Section 435. Restriction on powers of remission or commutation in certain cases. Plain English explanation. Section 435 places restrictions on the government's power to remit, suspend, or commute sentences in serious cases by requiring consultation with the central government in specified situations. Key points explained. When this restriction applies: when the offense was investigated by a central agency or relates to matters where the central government has executive power, e.g., national security, central laws. Mandatory consultation. The state government cannot act on its own. It must consult the central government before suspending a sentence, remitting a sentence, or commuting a sentence. Purpose of consultation: to ensure uniformity and coordination in serious or nationally sensitive cases, to prevent conflicting decisions between state and central authorities. Effect on earlier sections. This section limits the general powers given under Sections 432, 433, and 434 in the specified cases. Purpose of Section 435: to safeguard national interest, to ensure careful decision-making in serious offences, to maintain balance of power between state and central governments. Simple example: a person is convicted in a case investigated by a central agency. The state government wants to remit the sentence. Under Section 435, it must first consult the central government before granting remission. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 436. Section 436. Power to cancel suspension or remission. Plain English explanation. Section 436 explains what happens if a person who is granted suspension or remission of sentence violates the conditions attached to that benefit. It empowers the government to cancel the benefit and enforce the original sentence. Key points explained. When this section applies: when a sentence has been suspended or remitted under Section 432, suspension remission, or related provisions, and the convicted person breaks the conditions imposed. Power of the government. The appropriate government may cancel the suspension or remission and order that the remaining sentence be carried out. Arrest without warrant. After cancellation, the person may be arrested without a warrant and required to undergo the unexpired portion of the sentence. No effect on conviction. Cancellation affects only the benefit granted. The conviction remains valid and unchanged. Judicial oversight. Orders under this section remain subject to judicial review by the High Court if challenged. Purpose of Section 436: to ensure discipline and compliance with conditions of mercy, to prevent misuse of suspension or remission, to balance compassion with accountability. Simple example: a prisoner's sentence is suspended on condition of good behavior. he commits another offence or violates conditions. Under Section 436, the government cancels the suspension and he is taken back to prison to serve the remaining sentence. Bharatiya Nagarik Suraksha Sanhita, 2023 Section 437. Section 437, Power of Court to grant bail in non-bailable offences. Plain English explanation. Section 437 explains when and how a magistrate can grant bail to a person accused of a non-bailable offence. It also lays down important restrictions, especially for serious crimes. Key points explained. General rule. A person accused of a non-bailable offence may be released on bail by magistrate, but only at the magistrate's discretion. Serious offences, bail generally not allowed. Bail shall not be granted if there appear reasonable grounds that the accused is guilty of an offence punishable with death or life imprisonment. Exceptions, even in serious cases. Bail may be granted if the accused is a woman, a child, sick or infirm. Conditions of bail. The court may impose conditions such as appearance during trial, not committing a similar offence, not tampering with evidence or influencing witnesses, mandatory notice to prosecution. In serious offences, the court must give the prosecution an opportunity to be heard before granting bail. Recording of reasons. When bail is granted in a serious non-bailable offence, the magistrate must record reasons in writing. Purpose of Section 437. To balance personal liberty of the accused and interest of society and justice. To ensure strict scrutiny before granting bail in grave offences. To protect vulnerable accused persons through humanitarian exceptions. Simple examples. A person accused of a serious non-bailable offence bail depends on court's discretion. A woman accused of a serious offence court may still grant bail. Bail granted in a grave offence reasons must be recorded by the magistrate. Bharatiya Nagarik Suraksha Sanhita, 2023 Section 438. Section 438, Direction for grant of bail to person apprehending arrest, anticipatory bail. Plain English explanation. Section 438 allows a person who expects that he may be arrested for a non-bailable offence to apply for anticipatory bail. This means the court can order that if the person is arrested, he shall be released on bail immediately. Key points explained. Who can apply? Any person who has reason to believe that he may be arrested for a non-bailable offence, which court can grant anticipatory bail. The High Court or the Sessions Court. Nature of protection. It is a pre-arrest bail. The person is not arrested, or if arrested, is released immediately on bail. Conditions that may be imposed. The court may direct that the person shall cooperate with the investigation, appear before the police when required, not threaten or influence witnesses, not leave India without court permission. Discretion of the court. Anticipatory bail is not automatic. The court considers seriousness of the offence, role of the applicant, possibility of misuse of liberty, need for custodial interrogation, protection of personal liberty. This section protects individuals from false cases, harassment, unnecessary arrest. Purpose of Section 438. To safeguard personal liberty, to prevent abuse of arrest powers, to balance police investigation needs with individual rights. Simple example. A person fears arrest in a false non-bailable case. He applies to the Sessions Court or High Court. The court grants anticipatory bail. If police attempt to arrest him, he is released on bail immediately. Bharatiya Nagarik Suraksha Sanhita, 2023 Section 439. Section 439, Special powers of High Court or Sessions Court regarding bail. Plain English explanation. Section 439 gives special and wider powers to the High Court and the Sessions Court to grant, modify, or cancel bail, especially in serious or non-bailable offences. Key points explained. Who can exercise these powers? The High Court and the Sessions Court. Grant of bail. These courts can grant bail to a person accused of a non-bailable offence and already in custody. Their powers are broader than those of a magistrate. Imposition of conditions. The court may impose any conditions it considers necessary, such as appearance before police or court, restriction on travel, non-interference with evidence or witnesses, power to cancel bail. The High Court or Sessions Court may cancel bail granted by itself or by a lower court if bail conditions are violated or bail was wrongly granted. Opportunity of hearing. Before cancelling bail, the accused is generally given a chance to be heard. Purpose of Section 439. To give higher courts effective control over bail matters. To ensure justice and public safety in serious criminal cases. To correct improper bail orders passed by lower courts. Simple examples. A magistrate refuses bail in a serious offence. The accused can apply to the Sessions Court or High Court under Section 439. Bail is granted, but the accused threatens witnesses. The High Court may cancel the bail under this section. Bharatiya Nagarik Suraksha Sanhita, 2023 Section 440. Section 440, Amount of bond and reduction thereof. Plain English explanation. Section 440 deals with the amount of bond, bail bond, that a court can demand when granting bail. It ensures that bail conditions are reasonable and not excessive. Key points explained. Reasonable bond amount. The court must ensure that the amount of the bond is not excessive. Bail should not be denied indirectly by fixing an unreasonably high bond. Consideration of accused's circumstances. While fixing the bond amount, the court should consider the financial condition of the accused, the nature of the offence, and the risk of absconding. Power to reduce bond. If a bond amount is found to be too high, the High Court or the Sessions Court may reduce the amount. Purpose of sureties. The bond and sureties are meant to ensure the presence of the accused in court, not to punish or harass the accused before conviction. Purpose of Section 440. To protect the right to personal liberty. To prevent misuse of bail conditions. To ensure bail remains a practical and fair remedy, especially for poor accused persons. Simple example. A poor accused is granted bail but asked to furnish a very high bond. He cannot afford it. Under Section 440, the higher court may reduce the bond amount so that bail becomes effective. Bharatiya Nagarik Suraksha Sanhita, 2023 Section 441. Section 441, Bond of Accused and Sureties. Plain English explanation. Section 441 explains how a bail bond is executed when an accused person is released on bail, and what obligations the accused and the sureties must follow. Key points explained. Execution of bond. Before being released on bail, the accused must execute a bond, sign a written promise, with or without sureties, as directed by the court. Purpose of the bond. The bond is a promise that the accused will appear before the court whenever required and comply with bail conditions. Sureties. A surety is a person who guarantees the accused's appearance. If the accused fails to appear, the surety may have to pay the bond amount. Conditions in the bond. The court may include conditions such as attending court regularly, not committing a similar offense, not leaving the jurisdiction without permission. Binding nature. Once executed, the bond is legally binding on the accused and the sureties. Purpose of Section 441. To ensure the presence of the accused during trial. to balance personal liberty with judicial control, to create accountability through legal guarantees. Simple example: an accused is granted bail of 20,000 rupees with one surety. He signs a bond promising to appear in court. If he absconds, the bond may be forfeited and the surety may be required to pay the amount. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 442. Section 442, Discharge from custody. Plain English explanation. Section 442 explains when and how an accused person is to be released from custody after fulfilling the bail requirements. Key points explained. When this section applies: when an accused person is granted bail and has executed the required bond under Section 441. Duty of the officer in charge. The officer in charge of the jail or police station must immediately release the accused from custody once the bond and sureties, if any, are accepted. No unnecessary delay. Release should be prompt. Authorities cannot keep the accused in custody once legal requirements are completed. Lawful custody otherwise. The accused will not be released only if he is required in custody for some other case or some other lawful reason. Purpose of Section 442: to ensure effective implementation of bail orders, to protect personal liberty, to prevent illegal or prolonged detention. Simple example: an accused is granted bail by a court. He furnishes the bond and surety. Under Section 442, the jail authority must release him immediately, unless he is required in another case. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 443. Section 443. Power to order sufficient bail when insufficient bail furnished. Plain English explanation. Section 443 gives the court the power to act when the bail bond or sureties furnished by an accused are found to be insufficient. It allows the court to demand better or additional bail to ensure the accused's appearance. Key points explained. When this section applies: when an accused has been released on bail, but the bond amount is insufficient or the sureties are not reliable or adequate. Power of the court. The court may order the accused to furnish fresh bail or provide additional or stronger sureties. Failure to furnish sufficient bail. If the accused fails to comply with the court's direction, the court may commit him to custody until proper bail is furnished. Purpose is security, not punishment. The power is meant to ensure the presence of the accused during trial, not to punish the accused before conviction. Purpose of Section 443: to ensure that bail conditions remain effective and reliable, to prevent situations where weak or fake sureties defeat the purpose of bail, to maintain judicial control over persons released on bail. Simple example: an accused is released on bail with a surety. Later, the court finds that the surety is financially unreliable. Under Section 443, the court may order the accused to produce a new surety, failing which, the accused may be taken back into custody. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 444. Section 444, Discharge of sureties. Plain English explanation. Section 444 explains how and when a surety can be discharged from the responsibility undertaken in a bail bond and what happens to the accused after such discharge. Key points explained. Right of surety to apply. A surety may apply to the court to be discharged from the bail bond at any time. Action by the court. On receiving such an application, the court shall issue a notice to the accused and direct the accused to appear before it. What happens to the accused? When the accused appears, the court may require him to furnish fresh bail or commit him to custody until new bail is furnished. Effect of discharge. Once discharged, The surety is no longer liable for the accused's future conduct or appearance. Purpose of discharge. This provision protects sureties who no longer wish to bear responsibility or feel that the accused may abscond or violate conditions. Purpose of Section 444. To protect the interests of sureties. To ensure continued judicial control over the accused. To maintain the effectiveness of the bail system. Simple example. A person stands surety for an accused. Later, the surety fears the accused may abscond. The surety applies to the court under Section 444. The court discharges the surety and asks the accused to arrange a new surety or go to custody. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 445. Section 445. Deposit instead of recognizance. Plain English explanation. Plain English explanation. Section 445 allows the court to permit an accused person to deposit money instead of executing a bail bond with sureties. This is an alternative method to secure the accused's appearance before the court. Key points explained. Option of cash deposit. Instead of executing a bond with sureties under Section 441, the court may allow the accused to deposit a fixed sum of money. Discretion of the court. This option is not a right of the accused. It depends on nature of the offense, circumstances of the accused, satisfaction of the court, purpose of deposit. The deposited amount acts as a guarantee that the accused will appear before the court when required. Forfeiture. If the accused fails to appear or violates bail conditions, the deposit may be forfeited just like a bail bond. Helpful for poor or friendless accused. This section is especially useful when the accused cannot arrange sureties, but can deposit some money with the court. Purpose of Section 445. To make the bail system more flexible and human. To avoid unnecessary detention due to non-availability of sureties. To ensure attendance of the accused without hardship. Simple example. An accused is granted bail but cannot find a surety. The court allows him to deposit 10,000 rupees in cash instead. He is released on bail under Section 445. If he absconds, the amount is forfeited. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 446. Section 446. Procedure when bond has been forfeited. Plain English explanation. Section 446 explains what the court must do when an accused or surety breaks the conditions of a bond, for example, by not appearing in court. It lays down the procedure for forfeiture and recovery of the bond amount. Key points explained. When a bond is forfeited, if the court finds that the accused failed to appear or any condition of the bond was violated, the court will record the reasons and declare the bond forfeited. Notice to pay penalty. The court will issue a notice to the accused and/or the sureties, asking them to pay the bond amount, penalty, or show cause why it should not be paid. Recovery of the amount. If the penalty is not paid and no sufficient cause is shown, the court may recover the amount as if it were a fine or attach and sell property of the accused or surety. Imprisonment in default, surety. If recovery is not possible, the court may order civil imprisonment of the surety for a limited period as per law. Power to remit penalty. The court may remit, reduce any part of the penalty and enforce payment of only the remaining amount if sufficient cause is shown. Higher court's role. Orders under this section can be challenged before higher courts like the High Court. Purpose of Section 446. To ensure compliance with bail conditions. to make bail bonds effective and enforceable, to balance discipline with fairness by allowing explanation and remission. Simple example: an accused is released on bail with a bond of 50,000 rupees. He fails to appear in court. The court declares the bond forfeited, issues notice to the surety, and recovers the amount if no valid reason is shown. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 447. Section 447, Procedure in case of insolvency or death of surety or when a bond is forfeited. Plain English explanation. Section 447 explains what the court should do if a surety becomes insolvent, dies, or is otherwise unable to fulfill the responsibility of the bail bond, or when the bond has already been forfeited. It ensures that the accused remains properly bound to appear before the court. Key points explained. When this section applies: if a surety becomes insolvent, unable to pay debts, or if a surety dies, or if the court finds that the bond is no longer sufficient, or after a bond has been forfeited. Power of the court. The court may require the accused to furnish a new bond or provide fresh or additional sureties. Failure to comply. If the accused fails to furnish new bail or sureties as directed, the court may commit the accused to custody until proper bail is provided. Continuity of proceedings. This section ensures that court proceedings are not disrupted and the accused remains legally accountable to the court. Purpose of Section 447: to maintain the effectiveness of bail arrangements, to protect the court when a surety can no longer be relied upon, to ensure the presence of the accused during trial. Simple example: an accused is released on bail with one surety. The surety later dies or becomes bankrupt. Under Section 447, the court may order the accused to produce a new surety, failing which, the accused may be taken back into custody. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 448. Section 448, Bond required from accused and sureties. Plain English explanation. Section 448 explains that whenever an accused person or a surety is required to execute a bond under the Sanhita, the bond must be in the proper form and for the correct amount as directed by the court. Key points explained. Applicability. This section applies wherever the law requires execution of a bond, such as bail bonds, bonds for appearance, bonds after forfeiture or substitution of surety. Form of bond. The bond must be in the prescribed legal form and clearly mention the conditions and amount. Authority of the court. The bond must be accepted by the court or officer authorized by law. The court ensures the bond is legally valid and properly executed. Binding nature. Once executed correctly, the bond is legally enforceable against the accused or surety. Purpose of Section 448: to ensure uniformity and legality in execution of bonds, to avoid disputes about invalid or defective bonds, to strengthen the bail and security mechanism in criminal proceedings. Simple example: a court orders an accused to execute a bond of 25,000 rupees. The bond must be in the proper legal format and be accepted by the court. Only then is the accused lawfully bound by the bond. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 449. Section 449, Appeal from orders under Section 446. Plain English explanation. Section 449 provides the right to appeal against certain orders passed by a court when a bail bond is forfeited under Section 446. Key points explained. When this section applies. When a court passes an order under Section 446, such as declaring a bond forfeited or ordering payment of the penalty by the accused or surety. Who can file the appeal? The person affected by the order, such as the surety or the accused, if directed to pay the bond amount. Which court hears the appeal? The appeal lies to the higher court to which appeals from that court ordinarily lie. For example, to the Sessions Court or the High Court, depending on the case. Powers of the Appellate Court. The Appellate Court may confirm, modify, or set aside the forfeiture order or penalty. Purpose of Section 449: to provide a remedy against harsh or incorrect forfeiture orders, to ensure fairness to sureties and accused persons, to allow judicial review of bond forfeiture decisions. Simple example: a surety is ordered to pay 50,000 rupee after bond forfeiture. He believes the order is unjust. Under Section 449, he may file an appeal before the appropriate appellate court. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 450. Section 450, Summary Trials. Plain English explanation. Section 450 deals with summary trials, which are fast-track trials for certain less serious offences. It explains when and how a court can try a case in a summary manner, meaning in a quicker and simpler way than regular trials. Key points explained. Who can conduct summary trials? Only a magistrate who has been empowered by law to conduct summary trials. Eligible offences. Summary trials are typically allowed for minor or less serious offences, those specifically listed in the law for summary procedure. These offences do not require a full formal trial with all stages like a regular trial. Procedure. The procedure is simplified, faster, and less technical than an ordinary trial. Yet, the accused's basic rights are protected. Evidence and trial rights. The court still hears the evidence, allows the accused to defend, and ensures fairness. Purpose of summary trials: to speed up justice in minor cases, to reduce backlog and procedural delay. Purpose of Section 450: to ensure that petty offences are resolved quickly, to make the criminal justice system efficient and less burdensome for courts, to deliver swift justice without unnecessary formalities. Simple example: a person is charged with a minor theft or minor public nuisance offence. The law allows summary trial for such offences. Under Section 450, the magistrate can conduct a quick trial and deliver a swift decision. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 451. Section 451, Order for Custody and Disposal of Property Pending Trial. Plain English explanation. Section 451 gives the criminal court the power to decide how property connected with a criminal case should be kept, used, or disposed of while the case is still pending. Key points explained. When this section applies. When any property is produced before a criminal court, or when property is seized by the police and is related to a criminal case. Power of the court. The court may pass orders for proper custody of the property, safekeeping, or interim disposal of the property if necessary. Reasons for interim disposal. If the property is perishable, e.g., food items, or is likely to lose value, e.g., vehicles lying unused, or cannot be stored safely, the court may order its sale or disposal. Safeguards. The court may record evidence or photographs, impose conditions, or take a bond so that the property can be accounted for later during trial. applies till conclusion of trial. These orders operate during the pendency of inquiry or trial. Final disposal is decided later under the relevant section. Purpose of Section 451: to prevent damage, decay, or misuse of seized property, to ensure efficient management of case property, to reduce burden on police stations and courts. Simple example: police seize a vehicle used in an offence. Keeping it in the police station may cause damage. Under Section 451, the court may release the vehicle to the owner on bond or order its sale if appropriate, pending trial. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 452. Section 452, Disposal of property at conclusion of trial. Plain English explanation. Section 452 explains what the criminal court should do with property related to a case after the trial is over. Once the case is finally decided, the court must pass a final order regarding the property. Key points explained. When this section applies: after the conclusion of inquiry or trial, and when the court has passed a judgment of conviction or acquittal. Power of the court: the court may order delivery of the property to the rightful owner, or destruction of the property, or confiscation by the government, or any other appropriate disposal according to law. Who may receive the property? The person entitled to possession, or from whom the property was stolen or taken. Opportunity of hearing. Before passing the order, the court may give parties an opportunity to be heard, especially if ownership is disputed. Scope applies to property produced before the court or property seized by police during investigation. Purpose of Section 452: to ensure final settlement of property issues after the case ends, to restore property to the rightful owner, to prevent unnecessary retention of seized property. Simple example: a stolen mobile phone is produced during trial. The accused is convicted. Under Section 452, the court orders the phone to be returned to the victim. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 453. Section 453. Order may take effect subject to appeal. Plain English explanation. Section 453 explains when an order for disposal of property becomes effective and how it is affected if an appeal is filed against the judgment of the trial court. Key points explained. Normal rule: an order passed under Section 452, disposal of property after trial, does not take effect immediately. Waiting period: the order usually takes effect after the time for filing an appeal has expired, or after the appeal is decided if an appeal is actually filed. Purpose of delay: this delay ensures that the rights of parties are protected and property is not wrongly disposed of while the case is under appeal. Exception: immediate action. The court may order immediate delivery or disposal of property if the property is perishable, or immediate action is necessary in the interest of justice. Purpose of Section 453: to prevent irreversible loss or injustice during the appeal period, to ensure fair opportunity to challenge the trial court's decision, to balance finality of trial with rights in appeal. Simple example: a trial court orders return of seized property to a person. The opposite party files an appeal. Under Section 453, the property will not be handed over until the appeal is decided, unless the court orders immediate delivery for special reasons. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 454. Section 454. Appeal against orders under Sections 452 or 453. Plain English explanation. Section 454 provides the right to appeal against court orders relating to the disposal of property passed under Section 452 or Section 453. Key points explained. When appeal is allowed. If a criminal court passes an order regarding disposal of property after trial, Section 452, or postponement or immediate execution of such order, Section 453, any person aggrieved by that order may file an appeal. Who can file the appeal? The appeal may be filed by the person claiming ownership or possession of the property, or any other person affected by the order. Which court hears the appeal? The appeal lies to the appellate court to which appeals from that criminal court ordinarily lie. For example, Sessions Court or the High Court, depending on jurisdiction. Powers of the appellate court. The appellate court may confirm the order, modify it, or set it aside and pass a fresh order regarding the property. Purpose of Section 451: to protect property rights of affected persons, to ensure judicial review of property disposal orders, to prevent wrongful or unjust deprivation of property. Simple example: after a trial, a court orders seized property to be handed over to one party. Another person claims ownership of that property. Under Section 454, that person may appeal against the property disposal order. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 455. Section 455, Destruction of libelous and other matter. Plain English explanation. Section 455 empowers the criminal court to order the destruction of objectionable materials connected with certain offences after the trial is concluded. Key points explained. When this section applies. When a person is convicted of an offence relating to defamatory, libelous matter, obscene material, or other unlawful publications or objects, and such material has been produced before the court or seized during investigation. Power of the court. The court may order destruction of the offending material or any other appropriate disposal as permitted by law. Scope of materials. This may include books, pamphlets, papers, posters, photographs, electronic or printed material, or any object used for committing the offence. Final nature. Such an order is generally passed after conviction, ensuring that unlawful material is not circulated again. Purpose of Section 455: to prevent further circulation of harmful or illegal material, to protect public morality, reputation, and order, to ensure that objects used for committing offences are lawfully disposed of. Simple example: a person is convicted for publishing defamatory pamphlets. The court orders all seized pamphlets to be destroyed under Section 455 so they cannot be distributed again. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 456. Section 456, Restoration of Possession of Immovable Property. Plain English explanation. Section 456 empowers a criminal court to restore possession of immovable property, like land, house, shop, building, to a person who is wrongfully dispossessed by force or criminal intimidation after the accused is convicted. Key points explained. When this section applies. The accused is convicted of an offence involving criminal force or criminal intimidation or unlawful dispossession of immovable property. Power of the court. The court may order that the person dispossessed be put back into possession of the property. Time limit. The order for restoration must be passed within 1 month from the date of conviction. Who can be restored? The person who was wrongfully dispossessed or someone claiming possession through that person, like a tenant or legal heir. Independence from civil court. This order does not bar a civil suit. If a civil court later decides otherwise its decision will prevail. Purpose of Section 456: to give immediate relief to victims of forceful dispossession, to prevent accused persons from benefiting from illegal possession, to reduce prolonged civil litigation where criminal wrongdoing is proved. Simple example: a person is forcefully thrown out of his shop. The accused is convicted for criminal intimidation. Under Section 456, the criminal court may order immediate restoration of the shop to the victim. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 457. Section 457, Procedure by Police upon Seizure of Property. Plain English explanation. Section 457 explains what the police must do when they seize property during investigation and the property is not produced before a criminal court. Key points explained. When this section applies: when the police seize any property during investigation and the property is not immediately produced before a magistrate. Duty of the police: the police must report the seizure to the magistrate having jurisdiction. Power of the magistrate: after receiving the report, the magistrate may pass orders for proper custody of the property or order the property to be delivered to the person entitled to its possession, on such conditions like bond or security as the magistrate thinks fit. When the owner is unknown, if the person entitled to the property is not known, the magistrate may order the property to be kept in safe custody or sold if it is perishable or expensive to maintain. Temporary nature: orders under this section are interim, temporary. Final disposal is decided later under Section 452 after the trial ends. Purpose of Section 457: to ensure judicial supervision over seized property, to prevent misuse, loss, or damage of property in police custody, to protect the rights of the rightful owner. Simple example: police seize a motorcycle during investigation. The case is still under investigation and no court trial has started. Under Section 457, police report the seizure to the magistrate. The magistrate may order the bike to be released to the owner on bond. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 458. Section 458, Procedure where no claimant appears within 6 months. Plain English explanation. Section 458 explains what happens to seized property when no one comes forward to claim it within a specified time after the police report the seizure to the magistrate. Key points explained. When this section applies: property has been seized by the police and reported to the magistrate under Section 457 and no person claims ownership or possession of the property. 6-month waiting period: if no claimant appears within 6 months from the date of proclamation or notice, the magistrate may proceed further under this section. Power of the magistrate: the magistrate may order that the property be sold and the sale proceeds be credited to the government. Exception: perishable property. If the property is perishable or costly to keep, it may be sold earlier as per magistrate's directions. Future claim: if a person later proves that he was entitled to the property, he may apply for payment of the sale proceeds after deductions, subject to conditions and proof required by law. Purpose of Section 458: to prevent indefinite storage of unclaimed property, to ensure efficient disposal of seized items, to balance state interest with the rights of a genuine owner if he appears later. Simple example: police seize some jewelry during investigation. No one claims it for 6 months despite notice. Under Section 458, the magistrate orders the jewelry to be sold and the money is deposited with the government. If the real owner later proves ownership, he may claim the sale amount. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 459. Section 459 Power to sell perishable property. Plain English explanation. Section 459 empowers the criminal court or magistrate to order the sale of property that is perishable or costly to maintain even before the trial concludes, so that its value is not lost. Key points explained. When this section applies. When property is perishable, likely to decay or spoil, or requires high maintenance cost, or may rapidly lose value if kept unused. Power of the court or magistrate. The court may order immediate sale of such property, handling of sale proceeds. The money received from the sale is kept safely and treated as a substitute for the property. Final decision about the money is taken at the conclusion of the trial or under relevant disposal provisions. Protection of rights. Selling the property does not decide ownership and does not affect the final rights of parties. It only preserves the economic value. Purpose of Section 459. To prevent loss or wastage of seized property. To reduce burden on police stations and courts. To ensure practical and economical handling of case property. Simple example. Police seize fruits, vegetables, or livestock in a criminal case. Keeping them till trial would cause spoilage or heavy expense. Under Section 459, the magistrate orders immediate sale and the sale money is kept until the case is finally decided. Bharatiya Nagarik Suraksha Sanhita, 2023 Section 460. Section 460 Irregularities which do not vitiate proceedings. Plain English explanation. Section 460 explains that certain procedural mistakes, irregularities, committed by magistrate do not invalidate, vitiate the criminal proceedings as long as the magistrate acted in good faith. Key points explained. Good faith protection. If a magistrate honestly believes he has the authority to act, then minor procedural errors will not make the proceedings illegal. Types of irregularities covered. Examples include wrongly issuing a search warrant, ordering investigation, wrongly taking cognizance of an offense, issuing process, summons warrant, ordering bail or custody, making orders relating to maintenance or security. Condition. The protection applies only if the act was done in good faith. If there is malice, lack of jurisdiction, or bad faith, this section will not protect the act. Effect. Proceedings continue to be valid despite such irregularities. Accused persons cannot get the case quashed merely on these technical grounds. Purpose of Section 460. To prevent technical errors from defeating substantive justice. To protect judicial acts done honestly. To ensure smooth functioning of criminal courts. Simple example. A magistrate mistakenly orders an investigation believing he has power. Later it is found that the power was technically lacking. If the magistrate acted in good faith, the proceedings will not be set aside under Section 460. Bharatiya Nagarik Suraksha Sanhita, 2023 Section 461. Section 461 Irregularities which vitiate proceedings. Plain English explanation. Section 461 lists serious procedural irregularities committed by magistrate that invalidate, vitiate the entire criminal proceeding. Unlike Section 460, these acts are not protected, even if done in good faith. Key points explained. Serious lack of authority. If a magistrate does certain acts without having legal power, the proceedings become void. Examples of invalidating irregularities. Proceedings are vitiated if a magistrate, without authority, does things like taking cognizance of an offense, ordering investigation, issuing summons or warrants, holding a trial, passing a sentence, granting bail where he has no power to do so, no protection of good faith, Even if the magistrate acted honestly or mistakenly, the proceedings are still invalid if the power itself did not exist. Effect: such proceedings can be set aside or quashed by a higher court like the High Court. Purpose of Section 461: to ensure that only legally empowered courts exercise criminal jurisdiction, to protect individuals from unauthorized trials or orders, to maintain discipline and legality in criminal procedure. Simple example: a magistrate who has no power to try a serious offense conducts the trial and convicts the accused. Under Section 461, the entire trial is invalid and the conviction can be set aside. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 462. Section 462: Proceedings in wrong place, local jurisdiction. Plain English explanation. Section 462 says that criminal proceedings are not invalid merely because they were conducted in the wrong local area, jurisdiction, unless such error has caused a failure of justice. Key points explained. Wrong place alone is not fatal. If a case was inquired into, tried, or decided in the wrong local jurisdiction, it does not automatically become illegal. Test is failure of justice. The proceedings will be set aside only if the accused proves that the wrong place of trial caused prejudice or resulted in a failure of justice. Objection must be timely. If a party knew about the jurisdiction issue but did not raise it at the proper time, the court may ignore the objection. Higher court's role. A higher court, such as the High Court, will examine whether real injustice occurred, not just a technical mistake. Purpose of Section 462: to prevent technical objections from defeating justice, to ensure cases are decided on merits, not minor procedural errors, to promote efficiency and finality in criminal trials. Simple example: an offense is tried in District A instead of District B. The accused participated fully and suffered no prejudice. Under Section 462, the trial is not invalid merely due to wrong local jurisdiction. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 463. Section 463: non-compliance with provisions of Section 164 or Section 281. Plain English explanation. Section 463 deals with irregularities in recording confessions or statements. It explains when such irregularities will invalidate proceedings and when they will not. Key points explained. Sections involved. Section 164: recording of confessions and statements before a magistrate. Section 281: recording of statements of the accused by the court. Effect of non-compliance. If the procedure under Section 164 or 281 is not strictly followed, the confession or statement is not automatically invalid. Test of prejudice. The court will examine whether the accused was prejudiced or the confession or statement was not voluntary or truthful. Power of the court. If the court is satisfied that the confession statement was voluntary and the accused understood what he was saying, it may still admit the confession or statement in evidence. If prejudice is proved, if non-compliance caused coercion, misunderstanding, or injustice, the confession or statement may be rejected. Purpose of Section 463: to prevent technical lapses from nullifying genuine evidence, to protect the accused from forced or unfair confessions, to balance procedural safeguards with substantive justice. Simple example: a magistrate forgets to record one formal warning while recording a confession. The accused later admits the confession was voluntary. Under Section 463, the confession may still be treated as valid if no prejudice is shown. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 464. Section 464, effect of omission to frame or absence of or error in charge. Plain English explanation. Section Bharatiya Nagarik Suraksha Sanhita 2023 Section 464. Section 464, effect of omission to frame or absence of or error in charge. Plain English explanation. Section 464 explains that a criminal trial, finding, sentence, or order does not become invalid merely because there was a mistake related to the charge, unless that mistake caused a failure of justice. Key points explained. What kinds of mistakes are covered? No charge was framed at all, or the charge was framed incorrectly, or there was an error, omission, or irregularity in the charge. General rule: proceedings remain valid. Such mistakes do not automatically invalidate the trial, the conviction, the sentence, or the court's order. Test is failure of justice. The court will examine whether the accused was misled, or the accused was prejudiced in his defense, or there was a failure of justice because of the charge error. Power of the court. If the court finds that no failure of justice occurred, the conviction or order will be upheld. If the court finds that failure of justice did occur, it may order a new charge to be framed and a fresh trial, or appropriate corrective action. Role of higher courts. Higher courts, like the High Court, examine whether the accused knew the case against him and whether he had a fair opportunity to defend himself. Purpose of Section 464: to prevent technical mistakes in framing charges from defeating justice. To ensure cases are decided on substance rather than form. To protect the accused from real prejudice, not minor procedural lapses. Simple examples. A wrong section number is mentioned in the charge, but the accused clearly understands the allegation, trial remains valid. No charge is framed, and the accused is unaware of the offense he must defend. Conviction may be set aside and retrial ordered. Bharatiya Nagarik Suraksha Sanhita 2023 Section 465. Section 465, finding or sentence when reversible by reason of error, omission, or irregularity. Plain English explanation. Section 465 says that a conviction, sentence, or order will not be set aside merely because there was an error, omission, or procedural irregularity, unless that defect has caused a failure of justice. Key points explained. General protection against technical defects. Minor mistakes in procedure, summons, warrants, charges, trial process do not automatically invalidate the case. Test is failure of justice. The court must see whether the error actually prejudiced the accused, or affected the fairness of the trial, or resulted in a miscarriage of justice. Burden of proof. The person challenging the conviction must show that the error caused real injustice, not just a technical lapse. Timing of objection matters. If the accused did not raise the objection at the earliest opportunity, the court may presume that no prejudice was caused. Role of higher courts. Higher courts, like the High Court, will focus on substance over form and whether the accused had a fair trial. Purpose of Section 465: to stop criminal cases from failing due to mere technicalities. To ensure justice is based on fairness and merits, not procedural perfection. To promote finality and efficiency in criminal proceedings. Simple examples. A summons contains a small clerical error, but the accused appears and defends properly. Conviction will not be set aside. A serious procedural defect misleads the accused and harms his defense. Conviction may be reversed due to failure of justice. Bharatiya Nagarik Suraksha Sanhita 2023 Section 466. Section 466, defect or irregularity in sanction for prosecution. Plain English explanation. Section 466 explains that a criminal case will not become invalid merely because there is a defect, error, or irregularity in the sanction for prosecution unless such defect has caused a failure of justice. Key points explained. What is sanction for prosecution? In certain cases, especially involving public servants, prior government sanction is required before prosecution can begin. Effect of defect or irregularity. If there is an error, omission, irregularity, or defect in the sanction, the proceedings do not automatically become invalid. Test is failure of justice. The court will examine whether the accused was actually prejudiced or the defect resulted in a failure of justice. When proceedings may be set aside, only if the court is satisfied that the defect in sanction seriously affected the fairness of the case. Can the proceedings be quashed or set aside? Technical objections discouraged. Mere technical or formal defects in sanction are not enough to cancel the trial. Purpose of Section 466: to prevent criminal cases from failing due to technical defects in sanction. To ensure that trials focus on substance rather than form. To balance protection of public servants with effective prosecution. Simple example. A public servant is prosecuted with proper approval, but the sanction order contains a minor clerical mistake. The accused suffers no prejudice. Under Section 466, the trial remains valid and continues. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 467. Section 467 Powers of High Court to make rules. Plain English explanation. Section 467 gives the High Court the authority to make rules to regulate the procedure and practice of criminal courts under its jurisdiction, so long as those rules are consistent with the Sanhita and other laws. Key points explained. Who has the power? The High Court of a state. What kind of rules can be made? Rules relating to practice and procedure of criminal courts, management of cases, forms, registers, and records, administrative matters connected with criminal justice, condition of consistency. The rules must not contradict the Bharatiya Nagarik Suraksha Sanhita 2023 and not conflict with any other law in force. Binding nature. Once properly made, these rules are binding on all subordinate criminal courts within the High Court's jurisdiction. Purpose of rule making. To allow flexibility so that local needs are addressed, procedures remain efficient, and courts function smoothly. Purpose of Section 467: to empower the High Court to manage and regulate criminal court procedure effectively. To ensure uniformity and discipline in subordinate courts. To adapt procedural details without changing the substantive law. Simple example. A High Court frames rules on electronic filing of criminal cases or maintenance of registers in magistrate courts. These rules apply to all criminal courts in that state under Section 467. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 468. Section 468 Powers of State Government to make rules. Plain English explanation. Section 468 gives the state government the power to make rules to carry out and implement the provisions of the Bharatiya Nagarik Suraksha Sanhita 2023, as long as those rules are consistent with the law. Key points explained. Who has the power? The state government. Purpose of making rules. To give practical effect to the provisions of the Sanhita. To deal with procedural and administrative details not fully covered in the main law. Scope of the rules. Rules may relate to forms and registers, duties of police or court staff, procedural details for criminal proceedings, implementation mechanisms under the Sanhita, Condition of validity. The rules must be consistent with the Bharatiya Nagarik Suraksha Sanhita 2023 and not conflict with any other law in force. Binding nature. Once validly made, these rules are binding on authorities and courts within the state. Purpose of Section 468: to enable smooth and effective implementation of criminal procedure, to allow states to address local administrative needs, to complement the rule-making power of the High Court without overlapping or conflicting. Simple example: a state government frames rules about maintenance of digital records in police stations or procedural formats for criminal courts. These rules operate lawfully under Section 468. Bharatiya Nagarik Suraksha Sanhita 2023 Section 469. Section 469 Power of Central Government to make rules. Plain English explanation. Section 469 gives the central government the power to make rules for carrying out the provisions of the Bharatiya Nagarik Suraksha Sanhita 2023 in matters that fall within central jurisdiction. Key points explained. Who has the power? The Central Government of India. Purpose of making rules: to ensure effective implementation of the Sanhita across the country, to deal with procedural, administrative, or technical details that require uniform national standards. Scope of the rules. Rules may relate to procedures involving central investigating agencies, matters where the central government has executive power, forms, records, and processes applicable at the national level. Condition of consistency. The rules must be consistent with the Bharatiya Nagarik Suraksha Sanhita 2023 and not conflict with any other law in force. Binding effect. Once framed, these rules are binding throughout India in matters within central authority. Purpose of Section 469: to ensure uniformity in criminal procedure where national coordination is required, to complement the rule-making powers of the High Courts, Section 467, and the state governments, Section 468, to facilitate smooth functioning of the criminal justice system at the national level. Simple example: the central government frames rules regarding procedure for cases investigated by a central agency or national standards for criminal records. Such rules are valid under Section 469. Bharatiya Nagarik Suraksha Sanhita 2023 Section 470. Section 470 Repeal and Savings. Plain English explanation. Section 470 explains what happens to the old law and past actions after the Bharatiya Nagarik Suraksha Sanhita 2023 comes into force. It repeals the earlier law on criminal procedure and protects, saves, actions already taken under it. Key points explained. Repeal of old law. The earlier criminal procedure law, the Code of Criminal Procedure 1973, is repealed to the extent provided by law. From the date the new Sanhita comes into force, BNSS 2023 applies. Saving of past actions. Anything done, taken, ordered, commenced, or initiated under the old law remains valid if it is not inconsistent with the new Sanhita. Pending cases, investigations, inquiries, trials, or appeals already pending under the old law will continue as if they were started under the new Sanhita, unless otherwise provided. Protection from disruption. This section ensures no legal vacuum and no interruption in ongoing criminal proceedings. Purpose of Section 470: to ensure a smooth transition from the old criminal procedure law to the new one, to protect past and pending proceedings, to maintain continuity and legal certainty. Simple example: A criminal trial started under the old code before BNSS came into force. After BNSS starts, the trial continues without restarting. All valid steps already taken remain legally effective due to Section 470. Bharatiya Nagarik Suraksha Sanhita 2023 ends at Section 470, which is the last and final section of the Act. So, after Section 470, repeal and savings. No Section 471. No further provisions. If you want to continue studying, you can choose one of these logical next steps instead. Complete BNSS 2023 revision Section 1470. Important exam-oriented questions answers. BNSS versus CRPC 1973 comparison. Chapter-wise summary. MCQs short notes for judiciary or police exams.